The original DTCA is passed in 2012 at the end of the year, and it was intended to implement in legislation agreements covered by the Wassenaar Arrangement between some dozens of countries to regulate and control the international traffic in military and dual-use goods. How that would have impacted science and technology in Australia was quite severe. In particular, it would put the Defense Department in an oversight position over all such research, requiring that researchers in industry and government, in universities, to apply for permits to cover research projects across a wide range of disciplines, including a very large chunk of computer science. So high-performance computing is covered, cryptography, optical, telecommunications, signal processing, image processing, robotics, and artificial intelligence. The implications would have been that either researchers get such permits requiring continued government oversight and archiving, maintenance of records and so on, allowing inspections, or that they move out of that kind of research, or that they move overseas, or that they risk imprisonment for 10 years and a $400,000 fine. I think the overall implications of the original regime would have been that many areas of research in science and technology in Australia would, over a long term, radically decline. Foreign workers wouldn't be willing to come here. A lot of workers involved in the area would find new areas of research. To be sure, all of this was meant to control international so-called intangible transfers, so that means things like email, oral communications, telephone communications, and so on, that cross international boundaries. So if you were able, in fact, to quarantine all of your research activities so that it didn't spread across Australia, it would be possible to continue to pursue that. But under the original legislation, publication was considered such a transfer. So that means that ordinary university researchers where the end goal is publication, they wouldn't be able to do that without getting oversight and approval by the Department of Defense. But since publication is an open communication that doesn't respect international boundaries, publication is covered, and so would be blogging and anything else. Now, the recent legislation that was approved just a few weeks ago, the 2015 legislation, that's a result of Ian Chubb, our chief scientist steering group's investigation. They've came up with a set of amendments which allows for publication. So publication is removed from the control regime when we're talking about dual-use goods, that is to say non-military goods or non-military research. Publications allowed, and also oral communications. So many people seem to be of the view that saves the university-type open academic research community from any serious burdens in this legislation. But in fact, it omits coverage or exemption of a large range of activities that scientists do all the time and frankly need to do. So in particular, what I'm concerned about is not publication per se, because that's now permitted, it's allowed in general for dual-use goods. But there are all kinds of activities that surround and envelop publication that are not covered because they're not directly leading to a publication. So international collaborations, for example, if I communicate with partners or potential partners in Germany or the UK or New Zealand or Singapore about new research in any of these areas, in artificial intelligence, in Bayesian nets, automated decision making, machine learning that can be applied to image processing or signal processing, which is all kinds of machine learning. If I communicate new ideas about this across the international border with a view towards not directly for publication, but for just supporting generic ideas with like-minded colleagues, sharing ideas, encouraging each other's research, perhaps co-supervising students with those people, that is either permitted or it's illegal.
Oh. So how do you know that your ideas are new or novel enough to be to be dangerous according to what the government might think?
Well, that's a hard question to answer. That gets into a kind of nebulous area. Obviously, there's a gradation between new and old and significant and insignificant, and all of these things have to be negotiated in this law. So the risk, of course, well, that's part of the problem. The part of the problem is simply the vagueness of the interpretation of the law. You may well think that your research is either insignificant in terms of novelty, or has been covered by previous research, or is just putting other people's ideas together in a new way that's not very important. And the Department of Defense may take a different view of it. Unfortunately, if there's a disagreement of opinion there, then that could easily lead to prosecution. Yeah, you could view it as a kind of instance of the precautionary principle gone mad. As a Bayesian, I can't say that I'm particularly inclined towards accepting the precautionary principle anyway. The idea in environmentalism is that if there's any danger, then assume that the danger is highly likely to happen and act accordingly, which is not much, doesn't make much sense from a probabilistic Bayesian point of view. You don't take any possibility and convert them into probabilities just because they have negative consequences. Instead, you attempt, as a Bayesian, you ought to attempt to assess the probability independently of the consequences, and then add the consequences in and figure out for the available options, which in fact has the best expected value to take. So yes, it is an extreme form of the precautionary principle. It basically says if there's any kind of risk whatsoever in a dual-use good ever being used in a military way, then we should assume that will happen, that our direst enemies will pick up on this and use it against us. And that's not the way the world works. The high-performance computing that they're controlling, for example, that's used throughout the sciences nowadays for doing high-level simulations, mass particle simulations, agent-based modeling, discrete event simulations. It's used all the sciences use simulation now, and high-performance computing comes in as a key technology for implementing those kinds of simulations and advancing these sciences. By putting that under Defense Department constraints or sending it overseas, we're just handicapping ourselves and making it very hard for us to compete or participate in the new technologies that are coming on board. I think it's an overabundance of caution, let us put it that way.
Yeah.
From the Defense Department point of view, they're worried about the transmission of dangerous technology. Fair enough. But if they're going to hobble the development of useful and productive technology, the kind of technology that new economies are being built on today through the internet, if they're going to hobble Australia in this way, they're doing a great disservice, not just to researchers, to scientists in Australia, but to the entire Australian community, and ultimately to themselves. A dual-use good is, legally, it's just something which appears on the list of dual-use goods that the Defense Department has cobbled together out of prior lists generated by the United States military. The idea is that there are certain kinds of technologies, ideas, concepts, procedures, which are particularly useful potentially for the military, but are not, in fact, in the first instance, designed for military use. So just to give you some examples that they actually put in the list, there's fault-tolerant computing. Fault-tolerant computing has been around for a long time because computers, especially in the past, were very flaky devices. They failed quite often. So very early on, there was work on double and triple backup, triple modular redundancy, so that if one computer component failed, then the others would kick in. So there's hot backup computing. That's just one type of fault-tolerant computing. There's also error detection and correction in the transmission of information and in memory. So just to give you an example, dual-use goods list fault-tolerant computing specifically, and then the list exempts certain special cases. So error detection and correction in memory, for example, is exempted. If you do research on error detection and correction in memory, then you don't need a permit from the Department of Defense. On the other hand, if you do research on exactly the same algorithms, but it's not intended for use in memory, but use in telecommunications or data communications, then it's not exempted, and you need a permit or you go to prison. So that's an example of some of the silliness, actually, in the dual-use goods list. I don't know who came up with these lists, but in fact, they're not really appropriate. They're not internally consistent. They cover way too much ground, and there's way too much ambiguity in them. Another specific example in the dual-use goods list of integrated circuits which operate at greater than 40 megahertz. That's actually in the DSGL. And 40 megahertz was probably a high performance criterion about 30 years ago, but today it is not. So this is an example of them not keeping the list up to date. So integrated circuits are covered if they're anything like state of the art for 25 years ago or since then. What that means is that practically speaking, we couldn't possibly have serious chip manufacturing in Australia. Not that we do, but we could never get it because no major company, and only major companies do chip manufacturing, no major company is going to put their research processes under the direct control of the Department of Defense. It's preposterous. It won't happen. Any research that is currently covered in dual-use goods, such as Google may be doing in robotics, they will either quarantine it so that it doesn't have to communicate outside of Australia. Companies can do that sometimes. Or they will simply pull it out of Australia and leave Australia behind. Well, from the point of view of academic research, it compares highly unfavorably. Academic research is covered by DTCA. There's no general exemption for it. There's no general exemption for education as well. So I should mention that MOOCs, massive online courses operated by Australian universities across international borders, of course, because of the internet being such a communications device. MOOCs are covered by DTCA, so that means if in your courseware you cover any new ideas, if you take the fruits of your researchers and put them into your courses, and it's not an open publication, it's for those who subscribe, who enroll as students, that's a criminal offense. You can't do that. You have to publish it first, or you have to get a permit for it. So MOOCs are covered, all kinds of things are covered. All of these things are exempted in both the UK and the US. The UK has a very simple clause, I'll just read it to you, which immediately exempts this kind of thing. In the UK Export Control Act, it says, the communication of information in the ordinary course of scientific research, the making of information generally available to the public, or the communication of information that is generally available to the public, all of that is exempt from their corresponding law. Now, that particular clause has been put forward repeatedly in the context of the DTCA, that it ought to be incorporated into the DTCA. It was put as an amendment to the original bill in 2012. It's been put by me in submissions to the Senate. It's been put by me to Professor Ian Chubb. It's been put by me to the Department of Defense, and they refuse to act upon it. Instead, they prefer a whole lot of little tiny maneuvers dealing with publications, with oral communications, with other ineffective measures, half measures. They won't take the full measure. This would be an immediate exemption for everything significant that university research and university education does. There's no reason for the Department of Defense to require control over this kind of activity by universities. There's no reason for it. The UK doesn't do it. The US doesn't do it. If Australia does it, they will hobble the tertiary education, tertiary research. They will hobble us, and the result will be that the UK and US will streak ahead in this and in the industries that it underwrites, and Australia will lag behind. The primary relief that they've come up with in the amendment recently passed is the exemption of publications, open publications by Australian researchers, and the exemption for oral communications. There's been a fair bit of confusion about the latter exemption, by the way, and it's oddly enough just to do with understanding English. The law exempts oral communications. So if I'm invited to give a seminar, let's say in New Zealand, on Bayesian net technology, and I get up there and talk about Bayesian net technology and reveal some new ideas just orally, extemporaneously, then that's exempt. That's perfectly okay. As long as, to be sure, I can prove that that's how I revealed that information in the first instance, because oddly enough, the law, the DTCA as passed, as amended, reverses the burden of proof. So I have to prove that it was communicated orally. If I can't do that, then I can end up in the slammer. That is to say, if there's some other non-oral communication at the same time. For example, suppose I do an ordinary presentation with PDF slides. I project them on the wall, and I talk about the content of the slides. If I put a USB stick with those slides into a host machine, not my own machine, to do the projection in, say, Auckland, as I put that in there and transmit the PDF to the host machine, that is an intangible supply of the information in those PDF slides. So if that's the first communication of that information across international borders, then I'm a criminal. Speaking about it orally doesn't save me, unless I speak about it first. So if I'm in Auckland giving a presentation, if I communicate strictly orally, that's fine. If I speak extemporaneously without notes, that's fine. If I have notes, however, and I first insert them into a projector, a host computer, then that's an intangible supply of that information. And since that happened before any oral communication, that would mean I'm a criminal. So the oral exemption doesn't exactly cover the story. It certainly doesn't cover for a full-fledged multi-party collaboration, and it doesn't even cover it for giving seminars, because it's quite typical to carry PDF slides around and to make those available to your host in an international setting. So the confusion is that many people have said that the law exempts verbal communications. If they really did exempt verbal communications, then transmitting information on PDFs would be covered, because most such information is verbal. There are words. That's how the information is communicated. It's not oral. But in fact, the law simply exempts oral communication.
Well, I mean, what's the motivation between Australia trying to be so strict? Why? I mean, what on earth could they be trying to hide?
Well, I've heard a lot of speculation about the motivations, and I'm sure that different people have different motivations. So some people want to demonstrate to the United States just how helpful we can be in our security partnership with them. And I'm sure there are other people who don't really care about that, but are perfectly happy to take over the position of monitoring, controlling research across a broad range of science and technology. Why don't these protect science and technology research? Well, they do protect it in a very limited fashion. The problem is that the limited fashion isn't good enough. Most scientists active around Australia today communicate regularly with international partners, and they have to if they want to stay up with the state of the art. The state of the art is only in specific cases, in specific subdisciplines, set by what happens exclusively in Australia. It's rather rare. Mostly, the state of the art is being pursued simultaneously around the world, in the UK, the US, Canada, all kinds of countries. And you have to communicate with those people in order to stay in touch with what's happening. And sure, many of those communications have to do with publication. They may be directed at a publication, but many of them are not as well. So the idea of all of those things requiring permits from Department of Defense is frankly absurd. Of course, you can try to cover all of your actions that you can think of in advance that might engage international collaborators. You can try to do that, but inevitably people will fail. They will make mistakes. I will send things to joeblow@gmail.com, knowing that he lives in Sydney, knowing that he works there month in, month out. He's at some institution in Sydney and so on. But gee whiz, One of those months he happens to be in London, and the mail is received there. And there's an international criminal communication that the Department of Defense can use to arrest me. How does that make any sense? Absolutely. Cloud computing is problematic. The spokesperson from Defense at the forum suggested that cloud computing was perfectly okay. If you back up your information to Google Drive or whatever, then that's fine, as long as you aren't also, for example, giving access to that drive or that file to an international collaborator without permission. That was more or less the message that she was giving. But it's certainly not as clear as that. For one thing, Google Drive, being located in the United States, is subject to United States law, and that includes FBI access to anything that they deem they need. So they can request access, they can force access if they need to, and Google can't do anything about that. So under those circumstances, I think it's really just unclear. The law, the DTCA, doesn't go into cloud computing. There's it doesn't mention anything about it, any restrictions or any exemptions or anything like that. So I think that's just a matter of this particular person's interpretation. And that, again, is one of the problems with the law. There's a great deal of interpretation there. And if some people in defense this year say that cloud computing is fine, go ahead and back everything up. It could easily be the case that next year a different regime of bureaucrats in the Department of Defense says, no. Cloud computing is releasing all of your information over to the host. They can do anything they like with it. That's illegal. So the flexibility, the ambiguity in interpretation is something that really could be devastating. It introduces a great deal of uncertainty. Why should a PhD student, a beginning PhD student, or a beginning postdoc in any of these areas contemplating a job here in Melbourne versus an equivalent job in London, take the Melbourne job with all of these uncertainties hanging over their heads when the job in London is just as good? No, it's not going to happen. They're going to be moving to London. They're going to be moving to New York. They're not going to be coming here.
Well, have you got any examples where students have decided the latter, to move to another country?
Yes, it's already happened. There was a case just a few weeks ago with my colleague just a few doors down the hall here. He had a PhD student, a new enrolling PhD student, and gotten a scholarship and had heard about the DTCA. So he went to his embassy and found out more about the DTCA, and in consequence he's picking up a scholarship in the UK. Well, if we lose our best students, how can that be good for us? Yeah, well, there is the academic freedom side to things as well. Certainly the power given to bureaucrats to intimidate, to arrest, to investigate, to seize information. They can make copies of anything that's permitted, for example, under this legislation, at will, anytime they want. Those sorts of powers are bound to encourage academics to not speak their minds, to withhold any criticism of Department of Defense or the government of the day, or anybody who has this kind of power over them. I do not know. That's a very good question. I've been told that the Department of Defense has been telling everybody in one-on-one communications when asked that it's simply not workable, that the UK legislation is far too restrictive from their point of view, and they won't support it under any circumstances. But frankly, I think this is a political decision. It's not a bureaucratic decision. It's not a Department of Defense decision. The UK lives perfectly well under it. There's no reason why we can't do the same. In fact, the Department of Defense spokeswoman at the forum said that if we were to adopt the UK provisions, she said this at the forum, that it would make no practical difference to enforcement. If that's really true, then that's the strongest possible argument for adopting that provision. If it makes no difference to enforcement, then it makes no difference to international traffic in munitions or in dual-use goods. It makes no difference to them. It makes a damn lot of difference to researchers. It gives the kind of protection that researchers and educators need to continue doing their jobs. So that's thousands of reasons for adopting it and 0 reasons against adopting it.
I mean, it would cost a lot less I mean, to adopt a system that had already been proven?
Well, it wouldn't just cost a lot less because it's proven. It would cost a lot less because the permitting regime would be far more restricted. It wouldn't include what's happening in ordinary dual-use research at universities. Hundreds, perhaps thousands of bureaucrats, both in the Department of Defense and in the universities themselves, would not need to be hired in order to figure out what needs to be permitted, what doesn't need. Dual-use goods simply wouldn't have to be permitted in that case. So from the point of view of bureaucracy building, of course that's a terrible idea. You lose the potential for hiring hundreds of new employees to push around and do your bidding. But from the point of view of Australia getting on with its business, it's an incredible advantage not to have to build up those bureaucracies.
The more cogs in a system, the more parts that can go wrong.
The more friction in the system.
The more friction, the more replaceable parts, the more
breakdowns, the more fires. Yep.
So, I mean...
It's true, this is a boon for bureaucracy. Even my own university, the fastest growing part of the university has been, of course, the administrative center. This will be a big boon for them. They'll grow even faster.
Is this the future of work for human beings?
Are you suggesting artificial intelligence will take over the real work and human beings will be left to push paper around? Well, maybe in the rest of the world, but in Australia, if this legislation doesn't get changed, AI will die out. It won't be immediate. It'll be a long-term, painful death process. But with better students leaving, with better researchers not coming, with Defense Department overseeing everything we do, there's no question that it will eventually strangle the entire field.
So where does all this leave Australia's future in science and technology?
In that great dystopia that so many Hollywood directors have imagined. Yeah, I think either Australia collectively recovers its senses, or Europe and North America streak miles ahead, while Australia turns into something like a third world backwater.
Depending on resource sales in order to survive.
Well, we already depend way too much on resource sales to survive. Manufacturing has been largely killed off here by various governments. God knows why. Maybe you can explain that to me. But the new manufacturing, the new services, they're all internet-based. They're all knowledge economy-based. And this is going to do a great deal to kill that off. I think it's just bad collective decision-making. The politics in this country have been rather screwed up for some time. They aren't as screwed up in the United States. Actually, United States politics is crazy, but Australia is on the path towards that kind of craziness, where it's all about you versus me and black and white. It's either you're extreme libertarian, conservative lunatic, or you're an extreme leftist lunatic, and there's precious little in between. There needs to be common ground and a willingness to compromise. But the political institutions here don't seem to be able to find a way to do that. Resources are easy. They fit in with the libertarian go as you please mode. They don't require any processing. They don't require much in the way of governmental investment. So it sounds clean and easy. Of course, it's extremely dirty, and it doesn't build anything for the future. It's all about someone else building for their future, namely China. I think we ought to be building our future, not someone else's future.